Hi, my name is Julia Fleming. I'm an attorney in Ryan Swanson's Labor and Employment Group, and today I'll be talking to you about the current status of DEI in the workplace and how a recent Supreme Court decision has impacted this developing area of the law. To start, what is DEI? Diversity, equity, and inclusion are three closely linked values held by many organizations that are working to be supportive of different groups of individuals, including people of different races, ethnicities, religions, abilities, genders, and sexual orientations. Diversity refers to who is represented in the workplace. This can include diversity in gender, age, ethnicity, and physical ability. Equity refers to fair treatment for all people, so that the norms, practices, and policies in place ensure identity is not predictive of opportunities or workplace outcomes. Inclusion refers to how the workforce experiences the workplace and the degree to which organizations embrace all employees and enable them to make meaningful contributions. And so why is DEI important? Well, studies have shown time and time again that companies that are diverse, equitable, and inclusive are better able to respond to challenges, win top talent by better supporting their employees and promoting work environments employees want to stay in, as well as meeting the needs of different customer bases. In June of 2023, two cases were brought by Students for Fair Admissions against Harvard and the University of North Carolina in front of the Supreme Court in relation to the university's affirmative action initiatives. The question posed for the court was whether the admission systems used by Harvard and UNC were lawful under the Equal Protection Clause of the 14th Amendment. In short, the court answered no and overturned 20-year-old case law. The court ruled that educational institutions are no longer permitted to consider an applicant's race in making admissions decisions. Some brief facts about the case. Both Harvard and UNC's admissions processes were similar in that an applicant's race was considered throughout the review process. And ultimately, the universities were found to have used race as a plus factor in making a candidate more or less qualified to be admitted. The court found that the processes failed strict scrutiny and that the programs lacked sufficiently focused and measurable objectives warranting the use of race. They employed race in a negative manner, involved racial stereotyping, and lacked meaningful endpoints. The court limited how universities could consider an applicant's race and still allowed universities to ask applicants how race affected their life, so long as the discussion was tied to a quality of character or unique ability that the applicant could contribute to the university. Since this ruling, what many employers and companies have asked is whether it affects them, and the short answer is not directly. The Supreme Court's decision on affirmative action in university admissions is based on its interpretation of Title IX, which concerns discrimination by organizations that rely on federal funding, as well as on the Equal Protection Clause of the 14th Amendment, which applies to governmental entities rather than private parties. In contrast, private employers are governed by Title VII and state and local non-discrimination laws. So the Supreme Court's interpretation of Title IX and the Equal Protection Clause does not directly impact private employers. Moreover, the decision's ruling that universities cannot use race as a plus factor to give candidates a bump in admission decisions already equated to how laws stood in the employment context. It was already illegal to use race or other protected characteristics as a factor in employment decisions, such as hiring and any other significant decision related to the terms or conditions of employment. In the workplace, DEI initiatives are not about promoting protected characteristics, but rather they're about developing methods of attracting and retaining diverse talent, ensuring a diverse applicant pool, and removing barriers that could prevent individuals from minority groups from being hired. Therefore, regardless of the Supreme Court ruling, DEI initiatives should not condone preferential treatment based on race or other protected characteristics. In light of the decision, however, there have already been lawsuits brought by anti-affirmative action groups in relation to DEI programs. For example, several lawsuits have been brought against employers with diversity fellowships where eligibility for the fellowship depended on candidates' protected characteristics and minority status. Many of these lawsuits have since been dropped once the eligibility for the programs was expanded, so that applicants may now apply regardless of whether they belong to these underrepresented groups. Similarly, there can be lawsuits brought for reverse discrimination, brought by white employees against affirmative action programs that they allege result in unlawful discrimination. There can similarly be lawsuits brought for reverse discrimination, brought by white employees against affirmative action initiatives that they allege result in unlawful discrimination. When dealing with DEI initiatives and any other employment decision that looks to race or other protected characteristic as a consideration, employers must nonetheless use caution. Now, to discuss some best practices and do's and don'ts for employers to keep in mind. Employers should focus on inclusivity, maintain affinity and resource groups that are open to all employees, not limited to those with protected characteristics, like groups limited to race or gender identity. Employers should train hiring managers and interviewers on proper considerations and questions. What can and can't be considered when making hiring decisions? What are appropriate questions? And focus on the fact that employers should select the best qualified candidate for the job, regardless of a candidate's race, gender, age, or protected status. As well, employers can focus on broadening recruiting strategies. Even though employers cannot set arbitrary quotas or metrics to hire in a diverse manner, you still can ensure that you're recruiting from diverse candidate pools. If candidates with protected characteristics are underrepresented in employers' hiring pools, broadening this pool may attract more diverse candidates. This can look like advertising for a position using additional platforms or reaching out to local organizations that can help to reach a broader target audience. What employers should not do is create de facto hiring quotas, like setting a number or percentage of individuals with protected characteristics when it comes to employment decisions, incentivize decision makers to base decisions on DEI results, require diverse interview slates, make hiring decisions based on protected characteristics, or use racial data to boost or demerit a candidate to either seemingly make them more or less qualified. Overall, we are here to help, and some key takeaways from today should be that employers should strive to create an inclusive environment where individuals from all diverse backgrounds feel welcome, respected, valued, and supported, rather than work environments that feel exclusive with resources limited to individuals with certain identities. Essentially, if a policy, process, or practice requires knowing the racial characteristics of an individual to make a decision affecting their employment, you may want to have an attorney review it.